My name is LaSheena Williams. I am a family law attorney. I practice family law primarily out of Montgomery County, Prince George's County, and throughout the state of Maryland. And by family law, what that means is I do divorce, child custody, child support, paternity, pensions, retirement, pretty much anything that could go wrong in your relationship, I handle, from domestic violence on out. So as a family law attorney, I make sure that I can handle criminal cases that relate to family law, because a lot of criminal cases come from an ongoing an ongoing divorce case, or you might have a protective order that's filed as a result of a custody battle. That's what I do. So I try to make sure that I'm knowledgeable about all of those areas so that in the overall divorce and custody case, I can present well for my clients. Today we're talking about child custody and child support. So we're going to do an overview of this. This is my background information. I went to Howard University School of Law, Towson University. I'm currently barred in Maryland, DC, and the United States District Court. I am a member of several bar associations, including the ones I primarily practice in, which is Prince George's County and the Montgomery County. I'm also a member of the J. Franklin Bourne Bar Association, which is a specialty bar association for attorneys of African American descent who primarily practice in Montgomery County and Prince George's County. What we're talking about today, we're going to talk about custody. We're going to talk about child custody determinations and child custody modifications. We're also going to cover child support, why child support exists, and how child support is determined in Maryland and how it can possibly be modified. So in Maryland, there's two different types of child custody. There's legal custody and there's physical custody. And what that means is two very different things, even though everybody kind of sort of thinks of them as the same thing. Legal custody is the ability to make determinations and decisions for your children. It's where your kids are going to school. It's, are your children going to be vaccinated or not because of your beliefs? It's, are they going to go to private school or are they going to go to public school? What's happening, the dentist, everything. All of the important decisions that sort of manage your child's day-to-day life is what legal custody is. Now, in Maryland, we have several different types of custody. Legal custody is there's three. So there's sole legal custody, which is when one parent has the absolute right to make the decisions. So it's when that parent, doesn't matter what the other parent says, that parent is the one who has the ability to make that decision. So if I say, my kid needs vaccines because that's important to me and I don't want them getting the measles, and you're saying no because this is like a conspiracy or something from the government that happens, if you're the one with sole legal custody, you overrule. That's what that means, right? Joint legal custody means you have to come to a decision with the other parent. It means you both have to talk and come to a determination. You can't just unilaterally decide that your child's going to St. Mary's Catholic School when the other parent wants them to go somewhere completely different. That's not how that works. But sometimes the family relationship gets to be in such a way that you can't really work with the other parent if there's domestic violence involved, or if that parent just goes MIA, or they just want to cause you problems and make it difficult for you to make decisions on behalf of your children, which happens. Joint legal custody makes it a little bit more difficult. So we've got joint legal custody with tie-breaking authority. And what that means is, yes, me and you have to have a conversation, but I believe wholeheartedly in vaccines. And I don't care what you say. So I'm going to go get my kids some vaccinations because I have tie-breaking authority, which means that even if me and you can't come to an agreement, I'm going to make the final decision. Now, sometimes you have universal tie-breaking authority, whether it's religion or medical needs, and another parent might have it regarding education. But normally, without the help of an attorney, it's mostly one person has tie-breaking authority. Now, preemptive question, does this just mean I have sole legal custody? Well, that depends on which judge you ask, all right? Because what it means is, depending on if you happen to have a lawyer and you happen to understand the difference between somebody having tie-breaking authority or not, it means that technically some parents with tie-breaking authority can completely run over you without you having a say. But you can drag them into court over the fact that they aren't talking to you and they aren't communicating with you. And you can get this you can get it so that the legal custody is modified because they aren't acting in bad faith. They're not acting in good faith when it comes to making decisions for your kids, all right? So kind of it means sole legal, but it doesn't really mean sole legal. It really just depends on the judge and the county. It's not going to fly in Montgomery County. It might kind of fly in Prince George's, all right? So now we're going into physical custody. And physical custody is broken up into sort of 3 different sections. It's really 2, but when one person has sole physical custody, the other person can have visitation or access, all right? So the reason why it's broken up like this is going to be based on the child support guidelines, which is what we're going to get into a little bit later when we start talking about child support. What is shared physical custody? Shared physical custody is having, for the most part, at least 128 overnights with your kid during a year. And that means your kid staying with you. And why is it specifically 128 overnights? It's, again, an issue regarding child support. It's a child support issue. Now, a lot of people like to say, well, I just want 50-50 custody. That means they kind of talk to their friend, but don't necessarily understand what shared means. 50-50 doesn't necessarily mean shared. There's a lot of different ways you can get to shared custody. You can have a certain amount of weekend visits. You can have a certain amount of summer access. It doesn't necessarily mean your kid's with you half the time and your kid's with the other person half the time. It's just a matter of overnight visits. It's just a matter of being creative when it comes to getting to that overnight visits. If you've got a lawyer, your lawyer knows that you need to get to these overnight visits, and they'll work with you on it. If the other person doesn't know, then and you're not necessarily saying, well, I want 50-50, they don't necessarily know that the access schedule is going to impact the child support. A lot of people don't know it's going to impact the child support. All the lawyers know, but not a lot of regular people know. All right? There's different ways to get to the schedule. You can have a week on, week off schedule. That tends to work better with kids that are not at school age, or parents that live really close to each other and whose kids are malleable. If that doesn't work, and say one parent lives in California and one parent lives here, you can have all of the summer access. Say the parent in California gets all of the summertime and some of the school weeks. You're probably still not going to get to shared, but you're getting more access with your kid. Now, sole physical custody means you have your children most of the time. That means you have them so that the other parent has anything less than 128 overnights. Now, it could be 120 nights. It could be 12 nights. It could be no nights. But that means your kid's living with you most of the time, and that's going to impact your child support. Visitation and access is just the time you have with your children, right? So if you don't have any overnights, or if you have dinner visits, or if you have like one-day visit or whatever, that's access. So for example, if the dad has primary custody of the child and mom has access with the children alternating weekends and every Wednesday, just for the afternoons, just because math isn't my forte, but that's not going to get you to 128 nights. I wouldn't recommend that if the child support issue was important to you. But that does get you time with your children, and it may get you closer to getting shared access at a later time. Supervised visitations. Sometimes some people just dip out. They just dip out. And then all of a sudden, they want to show up and be in your kid's life. Somebody might have, I don't know, filed for child support, and they may be $20,000 in arrears, and they may feel some kind of way about that. So now all of a sudden, you got this parent saying, I want time with my kid. This is my kid. What do you want to do? It's like, look, buddy, the kid hasn't seen you in 5 years. We need to sort of get you to knowing the child, right? So they have supervised visitation centers. You could have a third party, a friend, aunt or something to make sure, you know, they know how to handle kids. There's not necessarily a preference for moms, and we're really, really getting further away from a mom preference here, to be honest. We're getting more and more liberal when it comes to access for dads. But if, for example, he completely disappeared and he has absolutely no idea how to change a diaper, you might want a sort of transition period where he's supervised and he knows how to handle your baby appropriately. All right? So, in making determinations regarding child custody, Maryland looks at like 20 different factors. These are most of the factors. These really are most of the factors. And a child custody determination isn't necessarily dependent on any one factor. It's dependent on a variety of these factors. So depending on how bad one of these factors might be, could completely change how the judge makes a determination regarding your access schedule. If you have a bad character or reputation, that might weigh into it. But if you both kind of have iffy characters, it evens it out. You know what I mean? So it does. I mean, you had the kid with them. You can't just say, oh my God, he had felony charges, this, that, and the other, but you had a baby with him and you were cool with it for like 8 years. And now it's a problem because you want child support. That's kind of a hard sell. You got to focus on other factors so that it sort of evens out. So let's say he disappeared for 5 years. That's a big deal. That's a big deal. So suddenly you disappear for 5 years. You get a notice from child support enforcement saying you owe me $20,000 and now we need 50-50 custody. That doesn't make sense. The kid's not used to that. The kid's been living with me every day. Say you can't keep a job. Say you're bouncing from couch to couch. Where is the kid gonna sleep? Where are they gonna sleep? But you want 50-50 custody. All you know is you want 50-50 custody, but you don't actually know how you're gonna actually pull this off. And if domestic violence is involved, that impacts the situation. So if there has been a domestic violence issue and I don't feel comfortable around you and I can't communicate with you, that makes it very unlikely we're gonna have shared legal custody because I can't talk to you because you might hit me, all right? So that automatically makes it an issue that pushes you away from joint legal custody or at minimum giving the other parent, the non-abusive parent, joint legal with tie-breaking authority. If my kid is currently going to private school, they've been going to private school for like the past 8 years, and you feel like they need to go to some free school in Charles County with a really bad, like, you know, test scores, why would they do that? Why would the judge do that? It doesn't make any sense. So it's a whole lot of factors that could all kind of make the situation look better or worse. It really could make it a better or worse. So you have to keep that in mind. It's a lot going on, and it's not just because I'm the mom, it's what I say. It's not just because she has no job, I should get the kid. It's a bunch of factors, depending on the magistrate or the judge you get, that could change how this whole thing plays out, all right? So, child custody modification. Child custody modification is different from establishing child custody. It's based on the same factors, but there's a hurdle you must overcome first. There has to be a material change in circumstance. A material change in circumstance could be as minimal as, oh, I moved to California, now we need to change the access schedule. Or, yes, me and you had a week-on, week-off schedule, but we now live 50 minutes apart, and I can't get the kid to school in the morning, and the kid's now going to full-time school. That's a material change in circumstance. You can't just get a child custody modification because you feel like it. You have to have a good reason for why the schedule, if you've already had a custody order, should be changed, all right? So you have to keep that in mind. There's lots of things that could get you to a material change in circumstance, but if you don't have it, doesn't matter what the situation is, you might not be able to get a modification. So you need that material change in order to move forward. You guys notice my pictures? I like pictures. I love pictures. So let's talk about child support. Child support is meant to help pay to ensure that a child has the financial resources available based on the parent's income. It's really a situation where it's based on the overall needs and expenses for the child. Child support's based on guidelines in Maryland. It's not necessarily limited to just income, but income is a predominant factor as well as access with your children. In Maryland, you have a child support obligation. You have a duty to support your kid, all right? If you and your girl or you and your husband or whatever decide that you don't want to go to court and fight over custody and y'all just want to work it out and you don't involve child support, that's fine, all right? You don't have to go to child support enforcement and get a court order. Even if you get a court order that says so-and-so has to pay child support, you don't have to make them do that. That's not something you have to do. You can work it out. It only comes into a situation where the government or the judiciary has to get involved is if so-and-so disappears and you now need help. Or if you need free resources like Medicaid when your child's father is an engineer and now you're using tax dollars to pay for free health insurance when the engineer dad could afford it, that's when child support enforcement's like, no, we're going to put him on an obligation, all right? So you have a duty to pay to support your children up until the age of 18 or until they graduate high school, but not beyond the age of 19, all right? And if your child has special needs, which makes it so that they can't necessarily support themselves, it may go beyond that period. That's kind of what we got. Now, I've already talked about guidelines, but Maryland child support guidelines means that's how child support is determined. If you and your partner have a combined income of less than $15,000, the guidelines are mandatory. Now, that can be a scary situation. But I've seen these guidelines worked all kinds of ways so that it makes sense for everybody and it's financially, affordable. What that means is you may or may not be, I don't remember what the slide next to this is. Now let's go back. All right, so you may or may not be on a sole custody guideline where one parent has primary access, primary custody, or a shared guideline. If you're on the primary guideline where you have sole custody, anything less than 128 overnights means you have sole physical custody of your kid. It could be 110 nights. It could be 7 nights. It could be no nights. What that means is you have the maximum amount of child support you can get. Now, if it's on the shared child support guidelines, anything over 128 overnights means that you have shared access. And the closer you get to 182 versus 183, the less child support you have. It may depend on the income disparity, and sometimes depending on how much the person with primary access makes, even if they have primary access, they may still owe the other parent money, which is why it's a good idea to run these guidelines with an attorney, or you can go down to the courthouse. Most courthouses have like free computers with an application called Sassy Calc on it. You could put your income in there, gross, not actual, gross income in there. You can put your health insurance for your child in there. You could put your daycare and aftercare costs in there. You can put their gross in there, and you can just start running guidelines to see how it goes, all right? So that's kind of a thing that you should really know before you really kind of go with child support, because you might not know what you're giving up. You might not have a single clue what you're giving up with child support. Or you might not have a single clue what you might owe in child support because you have the kid most of the time, but you so happen to make 3 times as much as him. Now you owe him $400 a month when you're the one with the kid. That's how you involve the court. You get what you get, so you gotta know before you go. So child support guidelines, it covers children's expenses. It also covers it covers the actual access schedule you have with your children. I put that in there because if you can get it modified so that if you're saying, well, I have 120 nights with my kid, or I have 145 nights with my kid, that will impact which calculator you use. And also what your ordered actual child support payments are and alimony decreases the amount of gross income you have available. What that means is if you owe alimony to your ex-wife and it's $600 a month, let's say you make $8,000 a month, it's minus the $600 a month, all right? If you have kids by somebody else and you already have court-ordered child support, your income is decreased by that amount of child support. So what that means is the first to the courthouse is the first to get the maximum amount of money. Now, I've had clients who did not know that she was the girlfriend and this guy had a whole wife and 2 like 15-year-old kids or whatever. But we got there first. And his wife went and she cried and he pays this and he pays that, but the judge didn't believe her. So now my client has all this money for this one baby, and now let's say it's, I don't remember what it is to be honest, but let's say it was $1,500 a month for this one kid because of daycare expenses. Pretty sure that's exactly what it was, but let's say it's $1,500. Now his wife, if his wife goes, his actual income is decreased by $1,500 before you start counting those 2 kids she has with him. So what's the first to the courthouse? It doesn't matter if you were necessarily the first to have this baby, all right? It's the first to the courthouse. So there's that. Yeah, I know his wife is mad. She doesn't even the wife didn't even like him, first of all, but she came because she was like, you're trying to take money out of my kids. He wasn't giving you any money to begin with. So it's a whole mess. Anyway, So child support guidelines take into consideration health insurance costs for your children, work-related daycare expenses, extraordinary medical expenses, and other expenses. You need to keep in mind that work-related daycare expenses are important. If you have a little baby and you're paying $500 a week for your kid to be in daycare because you have to work, your child support is going to be drastically higher than if you have a 13-year-old kid that's in school most of the time. Some guys forget to go modify their child support. I don't know why they forget to go modify their child support, but if my kid's not in daycare and you're not paying $2,000 a month for daycare, that sounds like a material change to modify my child support to me. Because now your expenses drop significantly because if you can't factor the work-related child care expenses in if they no longer exist. So I already covered this, but you don't necessarily have to pay for tutoring. You don't have to pay for summer camp. You don't have to pay for extracurricular activities. You don't have to agree to pay any of this. When you and your spouse or you and your partner were happy together and y'all made all these plans together about paying for a college education for your kid until they put you on child support, all right? You don't have to do that now, especially if it wasn't in writing. If it wasn't in writing, did it happen? I don't know. So that's how I kind of feel about it, all right? But they have no proof, and you're not obligated under the statute in Maryland to pay for your kids' education after they're 18. Child support modification, always modifiable. Case in point, if your kid's no longer going to $500 a week daycare, that's a reason to get your child support modified. If your kid's 18, that's a reason to get your child support modified. If you've had a decrease in income, that may or may not be a reason to get your child support modified, because you might have decided, oh, like the guy with the $1,500, pretty sure he's in the process of quitting his job because he's mad. But if he voluntarily impoverishes himself, that's going to set a whole other slew of problems for him. And a court may still impute income to you if they think you have actively decreased your income in order to get out of child support. I'm hoping he doesn't, because you know what? It's probably not going to work out for him. And his wife's still going to be mad about the fact that he has to pay this much money in child support to this other woman. That's my presentation on child support and custody. I try to leave a lot of time because a lot of people usually have a lot of questions. And I know I talk really fast, but this is basically like a free consultation. This is what happens when I go into consultation. Everybody tells me what all the problems they want to talk about are, and I let them know what the law is, and then I let them know what their options are, and then we kind of go from there. That's basically kind of what you got. I don't know how long I've been talking, but that's what we got. Does anybody have any questions about anything regarding custody? Yes?
Hey, my sister had a kid when she was 14.
Mm-hmm.
The guy was 3 times her age that got her pregnant, okay? She went down to try to get, child support, food stamps and all this, and because of her age, they told my mother that she was in charge of the kid.
Yeah.
But they also told my sister it was up to her whether she wanted to keep the kid or not. Not the father. The father didn't have to do anything. And it took us 2 years to get child support out of him, which only ended up being $200 a month. And he had his own business.
So that depends on what you can prove. And having your own business is complicated. It's complicated in that if you have a cash business, let's say you work at a nail salon or you're a hairstylist, on the record, you might be making $30,000 a year. But you know, like I know, that you're pulling $1,000 that's under the table. You know, everybody's gone to the salons where they say cash tips welcome. That's because you don't want to claim it on your taxes, right? So what you need, and your 14-year-old sister might not have known that, but what you need is you need to prove what is coming in versus what expenses for his business are going out to really show what his income is. Child support enforcement is like a viper. I don't know if anybody in here works for child support enforcement, but once they get their claws into you, it's tough to get out, all right? But getting to where you have a point where you can get the amount of income or the amount of support you need might be difficult because they're not going to necessarily pursue that information like an attorney might, right? But once they get their claws in you, you're kind of screwed. Like you're on the hook for that money and there's nothing you can really do about it. But if she couldn't prove he had more money than whatever the business was, then they can only work with the numbers they got.
Yeah, but the issue of it is why is the mom The
I don't know
one
what's
that's
going on with that
supposed
whole. That sounds like it was a while ago. I don't know what's going on with. It's probably because your mother was your sister was still like a minor, but I don't know what that is.
You know, my mom wasn't telling her to get rid of the kid or
Right.
to keep it. She told her to do what she wanted to do, and she was behind her 100%.
Right.
But financially, when you have somebody that's 3 times older than her that made her pregnant,
Right.
and my mom's reliable for all the costs, with, you know, the baby being at my mom's house, my sister still living there and everything.
Well, I know that I just recently went to a Maryland like statute and case law update, and I know that the laws are changing regarding third parties that are financially responsible for children. So yes, your sister, I mean, and I don't know, this wasn't clearly in effect when your sister was 14, but if your mother can collect child support for your sister's kid, if she's raising your sister's kid, I know you can do that. I don't know the logistics of why they said that she could keep it or not, but your mother can collect child support for her and enforce that for her, for the child, because she is watching the child. She's responsible. All right? All right. Yes.
I'd like to hear where you stand philosophically on what we now know are statistics that show that involvement of fathers in children's life is critical, and that a lot of things that we're seeing going on in society is a reflection of the lack of fathers being in their children's lives. In the process that you were involved in as an attorney, where's your stand on that? Where do you try to position that so that when you're dealing with a custody issue, you help both parties get past themselves and look to the benefit of the children?
See, that's complicated. It's a two-part answer to that. I pay attention to the courts and the judges and what the judges are likely to do on those issues, all right? So, for example, Prince George's County is a super liberal county. You get the right judge in Prince George's County, it doesn't matter how jacked up that judge is, how jacked up the dad is, you're probably gonna get shared legal or physical custody. Like, that's really kind of, this is being recorded, but it's totally true, all right? It is what it is. But me, I'm a lawyer. I'm gonna go with who's ever paying me, always. And that's just the perspective I got. So I got a lot of dads. Honestly, I mostly have dads. I prefer dads. But, I have both. It doesn't make much of a difference to me from an emotional standpoint because whoever's writing my checks is whoever I'm with. So I get what you're saying, and I just know that that's how I am personally. That's me personally as a person. I have absolutely no feelings about it. I just want to win. But I do know what the judges are likely to do in the counties I practice in. And I do know that the judges are moving towards a more liberal approach to dads. And they aren't taking it very kindly when women don't allow visitation or they're cutting guys off. It's the same story over and over again. I have guys come into my office on a weekly basis where it says, I was seeing my kid all the time, and all of a sudden, she stopped letting me see the kid. I was like, did you get a girlfriend? Did you get engaged? Yeah, how did you know? It's the same story every week, at least once a week, because that's what women, sometimes, no offense, totally do. Suddenly now he's a bad dad. Suddenly now he's a bad guy. He wasn't a bad guy last week when you didn't know about Stephanie, so now it's a problem, and judges get pissed. Judges get pissed. So it's just a matter of making sure you pay attention to what's going on, because that's not the only, that happens so much.
Thank you for that authenticity. What counties do you practice in?
I practice primarily in Prince George's County and Montgomery County. I have cases in Howard County. I'm all over the place that I can drive. So I have cases in Charles County and Howard County, Baltimore County, and Baltimore City. But most of my clients are in PG and Montgomery County.
What about Carroll?
I don't even know where that is. So no. I got a limit. If I can't point it out on Maryland map, I'm probably not going there.
Carroll, they're right next to
Still lost. I don't know what it is. So, it was her first, yeah?
I have a question. So, in my particular case, I have full legal and physical custody, but in Montgomery County, but I'm thinking about moving to DC. And what would I have to do to, transfer custody?
You can have your custody order enrolled in DC.
Oh.
So,
I have to go back to court for it?
No, you can just go. Well, once you've lived there for at least 6 months, just have it enrolled.
Huh.
Yeah, that's all you gotta do. I mean, it doesn't change anything. You're just, unless your order said Maryland will maintain jurisdiction, if you move and you've got the kids, after 6 months, just enroll your order, and then now DC has jurisdiction.
Okay.
All right?
What about grandparents?
Grandparents as to what?
I had my granddaughter for 3 years, and then her mom came back and took her.
So that depends, I think. The law's changed regarding grandparents' rights, and they're getting kind of more liberal regarding grandparents' rights. And as of like about 2 or 3 years ago, and there's been new case law recently. I don't have the case law to cite, but I do know that depending on how the characteristics of you positioning yourself, whether you were the parent or the primary caregiver of the child, if they take them, then you have a right to sort of sue for custody. If you've been held out as like the primary caregiver and that's what you were doing, you can sue for that. But if there's been a longer stretch, like if it's been 2 years since then, it's not as great. But if you had your kid for 3 years, right, and you've been taking her to school and you've been doing all this and you've been doing all that, and the mother was off living her life like she's childless, then you have a right to sue. Like the laws are getting way more liberal, oddly, when it comes to grandparents' rights.
She was then, well, my granddaughter's 4 now. Okay, I had her first 3 years of her life, and that's exactly what my daughter was doing.
Then you should probably file. And if you're in Montgomery County.
I was in Frederick County, and they told me I didn't have any.
When in Frederick County?
This was last year.
So the laws changed before that, right? It depends on how you pitched it, to be honest. Because the laws changed so that grandparents and same-sex partners have more rights. So a lot of the times, if me and you are in a same-sex relationship, and for all intents and purposes, this is my kid, you just happen to push it out, now I can't see my kid because me and you aren't together anymore. That's a problem. So if you're held out as a parent to this child, then you have standing at this point. Whether you're in a same-sex relationship or if you've been a grandparent and you've been holding yourself out as this parent, this kid believes you to be a parent, you have standing to fight for custody. All right? All right. Any questions?
Yes. So, like Montgomery County with a restraining order, and my spouse was kicked out from the visitation center, right? So then I had to go take the paperwork for child support to child support enforcement, right? He pretended he didn't get it, and then child support enforcement's like, oh, we're going to discontinue. So they sent it to the court, right? That's what they like typically do.
So hold up. Is the support based off of the protective order or is it based off a child support order?
There is no order except for the restraining order.
All right, then just file for child support.
That's what I did through the child support enforcement agency, right? And he's pretending that he didn't get it. So I guess someone took.
Did you file it in court too?
I think my lawyer that I have did, and so I think that's why that's when child support enforcement would be like, oh, we stopped, and they sent it to the court. Is that what they do?
So child support will do. Okay, so what they'll do is they'll try to sort of work it out, right? And they also try to reaffirm the other person's address in the process of trying to work it out because they're sneaky. They're like vipers, all right? But they are. I'm so serious. but if that doesn't work, they will totally sue him. But you're better off filing it. They will sue him like for child support for you on your behalf. So you would not necessarily need a lawyer, but it's always good to have a lawyer because your lawyer can dig for more information that child support enforcement won't. But when you filed with if you filed for a complaint for child support in the courts, you can get child support from the date that you file. Right. So the sooner you do that, instead of depending on the protective order that's going to evaporate in a year, the better, because then you're going to get more money for a long period of time.
Because of the emergency family maintenance.
Yeah.
I didn't do it, so I put him for contempt, right? And then because I needed TCA, I had to go to child support. And then the lawyer realized I did you know how you're not supposed to do everything individually, but I did because I didn't have any help. Then he just took it and just went like this.
Yeah.
And I think he put it in the court, so that's where it would go. It wouldn't just be.
You would be able to know. I don't know your name. Probably don't want to tell me your name in front of all these people about your business. But you can look your name up on Maryland Judiciary Case Search and see if you have an active complaint for child support. If your lawyer filed, you should see your name.
Right, so it would just be like bunched together, like it could be bunched together in the court system.
And Montgomery County's really, are you in Montgomery County? Montgomery County is really good about labeling all the issues that's currently going on in your case. They'll say everything. Child support, house, pension, retirement. They don't care. All right?
I went and just was every form that could be filled out to make sure that you stay there and I'm here.
But you're better off getting it in the court, because if you get it in the court, you can get arrears. And the sooner you get it in the court and you can get arrears, the more money you're going to get, regardless of whether they can find him today or they don't find him for 3 years. He's stacking arrears, and he's going to owe you money. And it's going to mess up his license, and it's going to mess up his passport, and it's going to mess him up. But you got to start the process correctly.
I did. I've been married for 15 years. Believe me, I was the first one to run to the courthouse. I'm the winner. I didn't play like that.
All right. Did you have any questions?
Yeah, I have a question. So in my situation, so she's 3.
Mm-hmm.
The first, basically, like 2 years of her life, her dad was MIA.
Mm-hmm.
And then I just placed him on child support. So
Mm-hmm.
he was upset and kind of went to that situation and was like, okay, well now I want custody.
Mm-hmm.
So he went to court, did the mediation, and he was granted every other weekend.
Mm-hmm. How many nights?
Just 2 nights.
From when to when?
So from Friday to Sunday after.
Okay. All right. That's
And
like.
so, so he was granted that. So he took that and went to child support office to get the child support cut down. And they granted it without contacting me.
What do you mean they granted it? How did he get summers?
So
Did he get summers?
he got 2 weeks in the summer.
All right. So look, I don't do math on the fly. All right. And I don't even have my phone to like kind of finagle this. But that's not 128 nights.
But they granted it anyway.
Well, how they granted it anyway?
I don't know. I wasn't even notified until after
The only way they could have granted it anyway is if his income went down in the process.
Please stop. So to him, he's told them that he's not working.
Well, yeah.
That's why.
Yeah, that's different. Now, that's a lie. That's why you need to go and.
But my thing is, as far as, so he got all of that, got the custody taken down, but he only came to get her 3 weekends, and then after that he stopped coming.
So when did the order happen?
In December.
It's August, right?
Yes.
So it happened in December. He only got it 3 weekends. When she starts going back to school, you should file again. Because you should file for a modification of custody and get it limited down to reasonable access, which means nothing. I mean, it sounds good. To people who don't know, it means nothing. But it means nothing.
You said reasonable
All right.
access.
Yes, reasonable access.
Why should she wait till she starts school?
She can do it now if you want to, but it seems like it's a fresh order. So other than the fact that he's only missed like a couple, he's just gonna start, like if you do it now, it's just gonna be like, oh, well, I'm seeing her now. I'm seeing her now. If she starts school, and I think it'll help. Because if it's a fresh order, it's fairly new order for custody. It's a fairly new support order. If you wait until she starts school, then the modification would be based on the fact, you can do it now, but you're just gonna be tangled up, and then you're gonna just have to do it again anyway when she starts school. And by then you're gonna pay out.
School like this fall, right? Or
It's
when
like-
she's of age?
When did she start school?
So she's in preschool now.
Mm-hmm.
And so her school is year round, so it doesn't stop.
So does she start kindergarten next year?
No, because she's only 3. She won't start kindergarten.
How long is
until she's
preschool?
5.
Like 2 years is preschool?
Mhm.
Oh, yeah.
Yeah.
All right. All right. So I would think you can do it now, but it might be tied up for an extended period of time, and you might not have a material change to warrant modifying the access. If he'll agree to you having an access modification, and you say, well, listen, I just want to know when you want to do this. Let's do Christmas and this, and then like let's just agree on other times together.
Get it right.
Which doesn't actually mean anything. Reasonable mutual access means nothing. If you have a custody order that says it, it means nothing. It means if me and you agree, that's when you see this kid. If me and you don't agree, whether you want to see this kid or not, that means you don't see this kid, and I am not violating anything because that's what the paper says. So what you might want to do, I'm just saying strategically, so like to maximize resources, if she starts to go to school, I mean, she's in preschool, but if she was in preschool when the order happened, then there's not really a change. If you move, then that's a change. If he's not seeing her, you could probably file, but then he's just gonna start trying to see her again. So if she's going to school and he can't do anything about it because he works too far away or whatever, plus it gives you a chance to get him employed. How long is he gonna stay unemployed? So you can stay unemployed for a prolonged period of time, but at a certain point, you're just voluntarily impoverishing yourself, and of course, you're just gonna be mad about it. So, I mean, it depends. I got one guy, all right, I represent everybody, like I said, okay? All right. I got one guy who is a mechanic. I don't know if he's gonna watch this. Anyway, look, he owe a whole lot of money, and he is like, I can't get my driver's license because I owe this money, and I owe this money, but I can't pay because I don't have my driver's license because of his whole job set, all right? So we're kind of in a catch-22 and to the point where the mother's just like, screw it, just take the kid, all right? It's kind of weird. Anyway, his situation's weird, but this guy hasn't had a job in like 3 years, I don't know. But child support enforcement's trying, but it's not really working out for him, for her anyway. So she's gonna get the kid. But long story short, I think you should strategically maximize your time by tracking the amount of times he's not seeing your kid for a prolonged period of time, maybe 6 months, maybe like a year. It's like, he saw her 4 times. Why should he have this schedule? Why should I be bound to this schedule where he's not actually seeing her? Then you can get your child support modified because you're getting custody modified. But don't let him have more than the actual access schedule you got, right? 2 nights every other weekend is pretty much the bare minimum, and you're trying to be a dad, just try. That's what most guys think is good for child support. It's totally not. It's a ripoff. You're never going to get to 128 nights like that. It's not. I sit there, do all the numbers. I'm bad at math. We got to do it. I got to count all sorts of stuff. But I do know that every other weekend, that's what, 26, that's 52. 52 ain't 128. Even if you add 2 weeks, that's 14. I don't know what 52 plus 14 is. That's what, 66? But I know it's not 128. I know that. And I know he can't get there, all right? So I would track it and then file. Track it for a prolonged period and then file. If you're tracking the calendar of times that he comes, he came, saw her for an hour, left, didn't take her. Just keep your calendar for like 6 months, like a year, and then file. So why are you trying to do it all of a sudden? You ain't been doing it now. Oh, so it started the second I filed for modification. That makes you look slick. People, all these judges see these cases all day long. They know when people are trying to be slick. Just like I know, oh, your child custody access suddenly modified because you got a girlfriend. I swear, I saw a dude on it Thursday. I see guys every week on the same stuff, all right? Judges aren't stupid. So that's what I would do if I were you. Yes?
Where's your office located?
My office is in Rockville. All right? Yes. Is that like a note? Just read it? Oh, thank you. Oh, very cool. It's long. I have joint legal custody with visitation and pay $300 a month in child support for my son. When my son was contacts. I'm sorry. My son was over on a weekend. He told me he doesn't live with his father over a year. He lives with his grandfather. Something lives with his girlfriend. Issue was brought up to child support. Child support confronted father. He denied it. Now my son hasn't been over anymore. Now I currently receive unemployment, still pay $300 when I have. All right, why don't you file for custody? You have joint legal with visitation. Why don't you file for custody? Your kid's 15. He could testify. I'm looking. Really don't know which one it is. I don't know. But all right, your kid's 15. He can say, I don't see my parents. I don't ever see him. I want to stay with my mother. At 15, a judge can talk to your kid. At 16, they almost have to talk to your kid, right? So file for custody and try to get him in front of a judge to say, I've been living with my grandparents. I want to stay with my mom. I never see my dad. This sucks, right? So that's what I think you should do, all right? I really might be looking at the wrong person, but that's what I think, all right? Because this is a ripoff, and that had to happen. One of my clients, the kid was living with the grandmother, and the mom was collecting all his money because he had a real nice job. She's collecting all his money. I was like, why don't you just get your kid more often and just like creep up on her with the access? So we kept creeping, and he kept getting more and more nights because the kid wasn't staying with her. She didn't care, and she didn't have a lawyer. So then, so we go to child support hearing, and they was like, well, how often is he staying with us? Like, he's staying over there like half the time. Oh, really? So now the child support went, whoom, whoom, whoom. But she was like, and then the judge was like, so is everybody like once it was over with, and his child support was so low because he makes a lot of money, and she works at like Walmart, and his child support was so low, and the judge was like, does anybody have any problems with what's going on? She's like, I got a problem with what's going on. But it doesn't matter, honey, because he's got the kid half the time. So that was on her for not knowing that. But you, kind of in the same situation, you need to creep that in, and then file. That's what I would do. Because that's what I did, and it totally worked. I think I got 5 more minutes. Does anybody else have any questions? You in the yellow, because I haven't heard from you yet.
So, like, I had a custody order like 2 years ago, but the father read the order the way he likes it. So, it states that the exchange of the child should happen in McDonald's, but he picked McDonald's in Woodbridge, Virginia, or like I have to drive like 2 hours each way. Oh, nice. So, how can I, for modification of the order, should I file, I mean, what I heard from lawyers is I have to file for a new, like a child custody, like the whole thing. If there is a way to just modify the order to be specifically stated, all the addresses, all the timing, and being between the lawyers, just to go in front of the judge without having the whole custody.
Yeah, you can have your lawyer ask him or ask his lawyer to modify it only as to that issue. If you're fine with everything else, you driving from here to Kingdom Come to get your kids doesn't help unless he lives somewhere like in Pennsylvania, and that's the only middle ground, right?
Until where is that area that he can do whatever he wants?
Well, where does he live?
He lives in Woodbridge.
Woodbridge?
Yes.
And he has primary custody?
No, I have primary custody, but he has like every other different visitations.
So you can always set it up so that the parent picking up drives. So is that what you have?
Well, he picked him from the school, let's say on Friday, but when there is no school, I have to, he said if you want to see your son, you have to pick him up from McDonald's and Dumfries or Woodbridge or whatever.
Right. So you can always have your lawyer ask him if you can come up with a solution that's closer. The easiest way to do it is whoever picks up, who's ever getting the kid picks the kid up, right? So that way, if you're not getting the kid, you don't have to be sort of uncomfortable about it, right? But if you have a lawyer and he has a lawyer, then your lawyers can communicate and you can agree on a modification. If he's refusing, then you can file to modify based on that issue. But at the end of the day, that sounds like something that like a logistical coordination thing. If it's just not working for you, you need to coordinate modifying that so that it makes the most sense. Because driving all the way to Woodbridge, Virginia to pick your kids up sucks. So you don't want to do that, all right?
Well, that's the main problem. For one day, sometimes he picks him on every other Sunday. For one day, my son stay in the car for 2 or 3 hours, 2 hours each way.
Yeah.
So he pick him in the morning, he drive back there 2 hours, I go pick him at night, 2 hours. That's not good for the child as well.
Yeah.
That is 6. So should I, if there is a way just to work it out, not with the whole trial, because what they told me, you have to pay $25,000 to get the whole custody trial.
I don't think you have to pay $25,000. I don't know which lawyers you got, but but if you have an attorney just write him a letter saying I want to modify, you could talk to him and try to get him to modify it. It's up to you. You don't have to necessarily go to court. This is the order, but you can agree to living under different circumstances if that's what you want to do. All right. If he's not going to agree, then you're going to have to make him. The question is, do you feel like paying to make him? It's not $25,000, I'll tell you that, but you're going to have to pay to make him. Either he agrees for cheap or you make him.
Look at you.
So what does this mean? This is how I'm serious. There's no real way to get it in like that. Like once you're in it, you're kind of in it. You can get a post-judgment settlement conference, or you can go to mediation over it, right? But if he's not going to agree, you're going to have to make him come out of pocket for his refusal to agree. It still might not work, but it's going to cost him money.
And that'll be okay.
All right? But thank you guys. I do believe that's it, probably. And
I had a comment about it.
oh, sure, what's up?
I was gonna say, my ex-husband lives pretty far, and so my daughter was doing the same thing for those weekends. Like I was traveling across the Bay Bridge, and so I went filed for, when I got custody, and so now the custody visitation is he has to come and pick her up in the DMV area, and not only that, but because she's involved with like extracurricular sports, like she's in a STEM club, and she does those things on the weekend, he has to spend time with her in the DMV. I don't care where he stays, right? But but what I'm not gonna do is keep driving 2 hours. I'm like, spending all this time in the car getting her back and forth. And it worked, and a judge approved it. And I didn't even have an attorney for that.
I don't think, I'm not saying that that's not possible. I'm saying because your kid's like 5, like those are different circumstances. Your kid's going to extracurricular activities, they're in programs and stuff, right? You have primary custody now, right? So if you open this can of worms up, you're like, well, why do you have to keep the kid? Why can't we go to Woodbridge, Virginia? We've got good schools. Try to do it for cheap, if you can. Then threaten him with legal whatever, right? So you've got like options, but the options get more expensive the further you go, okay? So that's what I think. It's just your kid's a little younger your kids sound older.
Yeah, she just turned 10.
Yeah, so it's like she's in school and stuff, right? But you already have primary custody. So be nice. If that doesn't work, have a lawyer threaten him. If that doesn't work, file something and threaten him through that. And well, that's what it all is. That's what it all sort of shakes out to be. So just different types of threats. But that's what I think, all right?
Thank you.
But thank you guys for coming. I really appreciate you listening to my presentation. Thank you.